SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law. This is lecture number 20. I am Dr. Ashutosh Acharya, Senior Assistant Professor from Law Center 2, Faculty of Law, University of Delhi. In this lecture today, we will talk about law of maritime dispute resolution. Now friends, we see that maritime transactions are huge in number. As far as shipping transactions are concerned, that is one whole area altogether. Apart from that, we also have law of the sea, which also falls somewhere down the line in this particular domain, where dispute resolution pertaining to sea areas are also to be undertaken. Now, what is the law that deals with maritime dispute resolution? Well friends, if we talk about earlier types of dispute resolutions, there was no distinctive law that was available in order to concretely identify that what will be the law that will be applicable as far as dispute resolutions are concerned. However, we have seen that states used to resolve their disputes peacefully. If they were to, then they could adopt modes of negotiation, conciliation, sometimes third party conciliation known as mediation, or sometimes arbitration. And we have seen in different scenarios that wherever such international disputes pertaining to maritime matters or sea matters are to be resolved, arbitration, negotiation, conciliations have been adopted by these states in order to resolve the disputes. Apart from that, we have also seen adjudication coming into being as far as maritime dispute resolution is concerned between two states. As far as ships are concerned, two individuals are concerned, then they can go for some kind of arbitration or negotiation or conciliation, which may be one particular kind of a standard form of arbitration mechanism, maybe in Singapore, maybe in India, or maybe in US, or maybe at Lloyd's market. So, different types of individual disputes can be resolved in these different areas and markets through different modes as to be chosen by the parties. Apart from that, we also see domestic laws getting applicable as far as adjudication in areas or in disputes which arises in certain domestic regions. For example, in India we have Admiralty Law Act 2017 or Merchant Shipping Act, which provides for the jurisdiction to the courts situated in different under the jurisdiction of different high courts in different states. So, those individual adjudications takes place as far as individual matters are concerned. But what if a dispute is between two states? What is the law with respect to governance of dispute resolution as far as its states are concerned? So, in order to look upon that particular aspect, we will today look at the different mechanisms of modern times which helps us resolve dispute, because in modern times we have moved ahead and moved so ahead that we now have a concrete legal system and procedure which not only recognizes amicable solution through conciliation, negotiation or arbitration, but we also have a specialized tribunal, we also have an adjudicating body which can help resolve the dispute between the two states, which is of maritime nature. Special focused tribunals have been established, special chambers can be established, a special type of arbitration can be undertaken as far as particular peculiar matters between the states is concerned. Such progress has been made as far as law of maritime dispute resolution is concerned. So, today in today's class we will look at this progression that has taken place, the present legal regime as far as maritime dispute resolution is concerned, which largely concerns dispute arising between two states, which may be with respect to act of ship or which may be with respect to the act of any organ of the state pertaining to the sea area, or act of a state directly as far as the sea area is concerned. Now friends, what can be different kinds of disputes or general disputes that we have seen so far has come into being. If I may take example of a decade before, when Italian Marines case happened and that was between India and Italy at International Tribunal for Law of the Sea, is a dispute of international nature between two states, wherein it was accused by the India that two Italian Marines had shot down the fishermen of India. Now, this particular dispute was supposed to be adjudicated, was supposed to be discussed and handled and tried at International Tribunal of Law of the Sea, which it did so as well. So, we see that this is one example. Another recent example could be referring of the dispute to arbitration against China by Philippines as far as South China Sea dispute is concerned, or for that matter, if you take the landmark North Sea continental shelf cases which was decided by International Court of Justice, or any recent case with respect to delimitation of continental shelf cases which may be pertaining, which may be, let us say for example, between Somalia and Kenya, or for that matter any other dispute with respect to division of continental shelf, or rights pertaining to the rights pertaining to or relating to flag states jurisdiction or flag states or the coastal states. A number of disputes can arise with respect to sea transaction, maritime transaction between states, and different options of dispute resolutions now have come into being. Now, what is the whole structure and how we undertake or states can undertake to resolve their dispute will be discussed in today's class. So, let us begin friends, the law of maritime dispute resolution. Let us have the introduction first. It is believed that 80% of the world's population lives on coastal areas, whilst 90% of international trade is done by sea. Furthermore, approximately 65% of the world's oil reserves and 35% of the world's gas reserves are located in the oceans. Historically, nations which have become great powers have been those with access to the sea. Examples can be drawn from United Kingdom, United States, France, Germany, Holland, Spain and Japan, to name but a few. Again, in modern times, seafaring countries such as China, India and Brazil have been predicted as emerging powers within the international community. The above statistics show that maritime activity substantially accounts for the economic strength of countries, and it is in this regard that international law is critical to navigating challenges, disputes that occur on the seas. International maritime disputes cover a wide expanse falling within the categories of public international law and private international law. Public international law refers the laws, rules and principles of general application that deal with the conduct of nation states and international organizations. It is sometimes referred to as the law of nations or just simply international law. It is distinct from private international law. Under public international law, sovereign states adopt by ratification, accession, international treaties and conventions to govern their relations with one another and international organizations. The Law of the Sea Convention, that is the United Nations Law of the Sea Convention 1982, categorizes the seas into three distinct areas, namely territorial waters, exclusive economic zone and international waters. Territorial waters are those under the sovereign control of coastal states and recognized under the convention as 12 nautical miles from the low water mark of a coastal state. All of this we had already discussed in the initial classes, lecture number 2, 3 and 4, where we understood the breadth of the territorial sea, how to draw those lines as far as territorial waters, contiguous zone or EEZ or continental shelf is concerned. This zone is under the exclusive economic zone, exclusive control of the specific coastal country. Ships of all nations are however allowed innocent passage in territorial waters. Beyond the territorial waters, 12 nautical miles is the EEZ, which goes further seaward to 200 nautical miles. Within an EEZ, the coastal state has special rights to use and exploit marine resources, enjoys freedom of navigation and other specified rights such as laying of marine cables. The area beyond 200 nautical miles is delimited as international waters, in which all states, coastal or non-coastal, have equal access, enabling them enjoy the freedom of the seas with other activities. The Law of the Sea Convention also provides rules pertaining to straits, archipelagos, enclosed seas, landlocked states, rules on jurisdiction over ocean vessels. Law of the Sea Convention provides for the rules to identify the three categories of the sea as discussed above. It leaves the actual delineation to states. States are therefore expected to hold discussions to arrive at consensus based on international law in order to achieve an equitable solution. Where states are unable to arrive at an arrangement within a reasonable time, they would then be expected to resort to various dispute settlement procedures under Part 15 of the Law of the Sea Convention. Now, this Part 15 of the United Nations Convention on Law of the Sea deals with dispute settlement and mentions the different kinds of dispute resolutions available as far as states disputes are concerned. Now, in the preceding paragraphs, as we see, we have identified the different stakeholders as far as the sea interest is concerned, or interest of the states in sea is concerned. And when these interests, either with respect to navigation or with respect to claim over sea is concerned, either the sovereignty or the economic rights of the states, when any dispute pertaining to such aspects come into being, what method or what particular type of settlement measure can be adopted or method can be adopted by the state in order to resolve dispute between those two states. We also see that since a sea is now considered to be highly economically viable in nature, economic resources are in abundance as far as sea is concerned. Now, this is the interest of not only coastal states, but it also raises the concern and interest of the non-coastal states. So, landlocked states or geographically disadvantaged states, they also have certain rights as far as the sea area is concerned, in addition to these rights of the coastal states. Now, when all of these states are having interest and rights in the sea, then obviously, if there is any dispute that comes into being, must be resolved amicably, peacefully. If it is resolved amongst themselves through conciliation or negotiation, nothing can be best than that. But if it does not reach to any particular kind of conciliation, negotiation, conclusion, then of course, other means and methods could be adopted as far as dispute resolution between the states pertaining to sea and maritime activities is concerned. Now, as I said, Part 15 mentions those methods. This includes non-compulsory dispute procedures such as mediation or the compulsory dispute procedures, which include the International Tribunal for the Law of the Sea, that is ITLOS, under Annex 6, the ICJ amongst others. Negotiation is the preferred method of non-compulsory dispute settlement by states, and the other avenues are considered only when negotiations stall. This is due to the fact that there is an increasing interest in exploiting maritime resources. During negotiations, state parties pursue a process of joint development in the maritime space to enable them set aside the legal dispute to focus on practical measures that ensure each state party's underlying objective. This is particularly so when each state party intends to pursue different types of exploitation. Some of the negotiations are 2003 negotiation between Azerbaijan, Kazakhstan and the Russian Federation, the 2004 negotiation between Australia and New Zealand, and 2008 Mauritius, Seychelles EEZ delimitation treaty are some of the other examples. When states reach a deadlock during negotiations, they resort to the compulsory dispute resolution mechanisms under section 2 of part 15 of the Law of the Sea Convention. Such mechanisms include the ITLOS under Annex 6, ICJ, creation of arbitral tribunal under Annex 7, and the creation of a special arbitral tribunal, which is a panel of experts dealing with disputes relating to specific areas such as fisheries, marine environment and scientific research, to name but a few. Since 1994, arbitrations under Annex 7 of the Convention of the Law of the Sea have become a popular means of resolving maritime disputes falling within the ambit of public international law. The latest example that can be taken is between the Philippines and China, where ex parte decision in favor of the Philippines was provided. In some examples of the Law of the Sea Convention, Annex 7 arbitrations include Australia and New Zealand versus Japan, Southern Bluefin Tuna arbitration, then Ireland versus UK, Mox Plant arbitration, or Malaysia versus Singapore, land reclamation arbitration. The main source of contention among states under the Law of the Sea Convention has been maritime boundary disputes. They relate mostly to the delineation of the baseline and delimitation of the territorial sea, the EEZ and the continental shelf within or beyond the designated 200 nautical mile area. Another significant mechanism of dispute resolution introduced by the Law of the Sea Convention is the International Tribunal for the Law of the Sea, ITLAS, situated in Hamburg, which hears both contentious and non-contentious matters. It plays a significant role in hearing prompt release cases which are expedited due to the nature and context of such cases. For instance, seizure of a foreign ship and its crew by coastal state, usually in its EEZ. Such disputes are not limited to state actors, and natural or legal persons may appear before ITLAS with the permission of their flag state. It is worth noting that even though ITLAS provides an avenue for settling both contentious and non-contentious matters, disputes brought before it have been relatively minimal, most of which have related to prompt release matters. In effect, ITLAS rarely decides cases on the merits, although states have mostly preferred litigating before the International Court of Justice. This trend is changing and the number of cases being registered before ITLAS are increasing. These include ITLAS case number 16, dispute concerning delimitation of the maritime boundary between Bangladesh and Myanmar in the Bay of Bengal, and ITLAS case number 23, dispute concerning delimitation of the maritime boundary between Ghana and Côte d'Ivoire in the Atlantic Ocean. As already indicated and discussed, dispute settlement by the ICJ is the predominant mechanism for maritime disputes under public international law. Therefore, the main forum for states seeking judicial settlement under the Law of the Sea Convention is the International Court of Justice. In addition to Law of the Sea cases, the ICJ also decides on maritime and sovereignty issues. Some of the ICJ judgments on the Law of the Sea since 1994 include 1998 Fisheries Jurisdiction, Spain versus Canada, 2001 Maritime Delimitation and Territorial Question, Qatar versus Bahrain, 2002 a Land and Maritime Boundary, Cameroon versus Nigeria, pertaining to Equatorial Guinea intervening, 2007 Territorial and Maritime Dispute in the Caribbean Sea, Nicaragua versus Honduras, in 2012 Territorial and Maritime Dispute between Nicaragua and Colombia, 2009 Maritime Delimitation in the Black Sea, Romania versus Ukraine, 2014 Maritime Dispute between Peru and Chile, 2014 Whaling in the Antarctic, Australia versus Japan, New Zealand intervening, 2021 Maritime Delimitation between Somalia and Kenya. Now, let us look at the different options available as far as dispute resolution is concerned. So, we look at all the options, where they are situated, under what law they are in existence, and what are their primary tasks as far as the process of dispute resolution or the option of dispute resolution is concerned. So, let us start with ITLAS first. This chart as it represents, it is an independent judicial body which is established by United Nations Convention on Law of the Sea. We will look at it in detail also, what is the composition of ITLAS and what is the functions of ITLAS in general. Then established by part 15 of United Nations Convention on Law of the Sea, its headquarters are in Hamburg in Germany. It adjudicates UNCLOS relevant disputes. It is the primary forum for disputes related to the law of the sea, maritime boundary disputes, freedom of navigation and marine exploitation. Also provides advisory opinions on other maritime matters. Then we have International Court of Justice. While not exclusively a maritime court, the ICJ hears cases related to the law of the sea and maritime boundaries when states or United Nations submit disputes to it. The principal judicial organ of the United Nations organization, we can say it is a principal adjudicating body established in June 1945 by the UN Charter, which began work in April 1946. It is located in Peace Palace, The Hague, Netherlands. The primary function is the general reference for disputes between states as per the statute of the ICJ. Then apart from ICJ and apart from ITLOS, which are largely the adjudicating bodies, we have the option of arbitration, wherein we have Permanent Court of Arbitration. It facilitates arbitration and dispute resolution between states. It is situated in The Hague, Netherlands, has been involved in maritime disputes related to the law of the sea. Ad hoc arbitral tribunals are also available, which are constituted to address specific maritime disputes between states. And when I say specific, we mean to say certain technical aspects of disputes, not the general ones, and for that ad hoc arbitral tribunal may be placed. Now, as per the directive of the ICJ or UN Security Council mandate, it will sit. Since it is ad hoc, it does not have a specified place of sitting. Establishment and procedures are outlined in specific agreements or conventions between disputing parties. Then we also have ITLOS under Annex 7 Arbitral Tribunal address disputes submitted under Annex 7 of UNCLOS. They are established under UNCLOS. Annex 8, Annex 7 is the court of arbitration responsible for the resolution of disputes relating to the law of the sea. Then apart from that, we have International Seabed Authority, which is an administrative tribunal. It deals with these disputes arising under Annex 8 of the UNCLOS. The headquarter is located at Kingston, Jamaica. It came into existence on November 16, 1994. It helps in resolution of disputes related to the exploitation of mineral resources in the deep sea bed. Special Arbitral Tribunal under Annex 8. It is established under UNCLOS Annex 8, situated at Hague, the Netherlands. Resolution of disputes related to the exploitation of mineral resources in deep sea bed. Now, let us start by looking at the specific provisions which talks about settlement of dispute or dispute resolution. Now, as I said already that part 15 of United Nations Convention on Law of the Sea deals specifically with the settlement of disputes. So, we will look at part 15 and the provisions specifically, what does it say and what options does it provide, and what are the mandatory obligations upon the states or non-mandatory obligations upon the state as to resort to the pacific settlement of dispute or the type or kind of pacific settlement of dispute. So, part 15 settlement of dispute, section 1 gives us general provisions. Article 279 talks about obligation to settle disputes by peaceful means. States parties shall settle any dispute between them concerning the interpretation or application of this convention by peaceful means in accordance with Article 2, para 3 of the Charter of the United Nations, and to this end shall seek a solution by the means indicated in Article 33, para 1 of the Charter. Article 2, clause 3 says all members shall settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. So, if Article 279 makes an obligation to settle dispute by peaceful means, which should be in accordance with Article 2 and para 3 and Article 33 para 1. So, Article 33 para 1 says that the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements or other peaceful means of their own choice. So, basically Article 279 of the United Nations Convention on Law of the Sea is in compliance to Article 2 and Article 33 of the United Nations Charter, and it fulfills the objective. Article 280 talks about settlement of disputes by any peaceful means chosen by the parties. Nothing in this part impairs the right of any state's parties to agree at any time to settle dispute between them concerning the interpretation or application of this convention by any peaceful means of their own choice. Article 282 talks about obligations under general, regional or bilateral agreements. If the states parties which are parties to a dispute concerning the interpretation or application of this convention have agreed, though a general, regional or bilateral agreement or otherwise, that such dispute shall, at the request of any party to the dispute, be submitted to a procedure that entails a binding decision, that procedure shall apply in lieu of the procedures provided for in this part, unless the parties to the dispute otherwise agree. So, if the parties have an option of resolving dispute, a method or a mode through which they are going to resolve the disputes, then that will be binding upon them. So, there must be some peaceful method through which they must be resolving their dispute. In that particular scenario, the method or the mode of dispute resolution mentioned in an clause can be allowed to be exempted. Article 284 talks about conciliation. Conciliation is a kind of mandatory process through which all the states which are in dispute or which are undergoing through dispute amongst themselves of any nature must undergo this particular process of conciliation. And if they fail to reach to a particular conclusion, that is, if they fail to resolve their dispute, then they can move ahead with any other mode of dispute resolution mechanism. But first they must go for conciliation, and it's wherein article 284 says that a state party which is a party to a dispute concerning the interpretation or application of this convention may invite the other party or parties to submit the dispute to conciliation in accordance with the procedure under Annex 5 Section 1 or another conciliation procedure. If the invitation is accepted and if the parties agree upon the conciliation procedure to be applied, any party may submit the dispute to that procedure. If the invitation is not accepted or the parties do not agree upon the procedure, the conciliation proceedings shall be deemed to be terminated. Unless the parties otherwise agree, when a dispute has been submitted to conciliation, the proceedings may be terminated only in accordance with the agreed conciliation procedure. Section 2 talks about compulsory procedures entailing binding decisions. Now, this is a very peculiar and very progressive section as we see, because if you look at internationally, generally we have seen that very rarely there is a binding dispute resolution mechanism in place in different conventions. United Nations Convention on Law of the Sea is one of its kind convention where it provides for binding and mandatory dispute resolution mechanism. We cannot allow, or this particular convention does not allow the states to not to have any one particular mechanism to resolve their dispute. In all scenarios, it must choose any of the mentioned dispute resolution mechanism. Now, there are 4 dispute resolution mechanisms that have been mentioned, such as ITLOS, International Court of Justice, arbitration under Annex 7, or the fourth one will be the Special Arbitral Tribunal. Now, if the state chooses any one of the mechanism, it will be considered to be binding upon that particular state. Now, what if the state fails to choose any one of the dispute resolution mechanism? In that scenario, arbitration under Annex 7 or before an arbitral tribunal would be the default mechanism for that particular state which is in dispute with any other state. So, there is a default dispute resolution mechanism in place that even if you fail to choose or if you wish not to choose, and if there is a dispute in future, arbitral proceedings will be applicable as far as the dispute between the two states are concerned. Now, this is one peculiar feature that we see distinct from other conventions that come into being, and that is the clause, that is the section of dispute resolution, and that too a binding one. And the decision of that, of the arbitral proceeding or of the arbitral tribunal, or if any other tribunal or the court is chosen, then the decision of that court or tribunal will be considered to be binding. So, in this line, article 286 says application of procedures under this section subject to section 3, any dispute concerning the interpretation or application of this convention shall, where no settlement has been reached by recourse to section 1, be submitted at the request of any party to the dispute to court or tribunal having jurisdiction under this section. 287 talks about choice of procedure, an important provision which says that when signing, ratifying or acceding to this convention or at any time thereafter, a state shall be free to choose by means of a written declaration one or more of the following means for the settlement of dispute concerning the interpretation or application of this convention. Friends, if you note the line, it says states shall be free to choose. So, states are though free to choose, but they have to choose, they are bound to choose any one of the mechanisms. So, what are the mechanisms? As I said, it will include the International Tribunal for Law of the Sea established in accordance with Annex 6, then the International Court of Justice, an arbitral tribunal constituted in accordance with Annex 7, or a special arbitral tribunal constituted in accordance with Annex 8 for one or more of the categories of the disputes specified therein. A declaration made under para 1 shall not affect or be affected by the obligation of a state party to accept the jurisdiction of the seabed disputes chamber of the International Tribunal for the Law of the Sea to the extent and in the manner provided for in part 11 section 5. A state party which is a party to a dispute not covered by declaration in force shall be deemed to have accepted arbitration in accordance with Annex 7, as I have already told you. If the parties to a dispute have accepted the same procedure for the settlement of dispute, it may be submitted only to that procedure unless the parties otherwise agree. Further, if the parties to a dispute have not accepted the same procedure for the settlement of dispute, then in that particular scenario, it may be submitted only to arbitration in accordance with Annex 7 unless the parties otherwise agree. A declaration made under para 1 shall remain in force until 3 months after notice of revocation has been deposited with Secretary General of the United Nations. A new declaration, a notice of revocation or the expiry of the declaration does not in any way affect proceedings pending before a court or tribunal having jurisdiction under this article unless the parties otherwise agree. Declarations and notices referred to in this article shall be deposited with the Secretary General of the United Nations, who shall transmit copies thereof to the state parties. Now, Article 288 talks about jurisdiction, and it says that a court or tribunal referred to in Article 287 shall have jurisdiction over any dispute concerning the interpretation or application of this convention which is submitted to it in accordance with this part. A court or tribunal referred to in Article 287 shall also have jurisdiction over any dispute concerning the interpretation or application of an international agreement related to the purposes of this convention. Further, the seabed dispute chamber of the ITLOS established in accordance with Annex 6 and any other chamber or arbitral tribunal referred to in part 11 section 5 shall have jurisdiction in any matter which is submitted to it in accordance therewith. In the event of a dispute as to whether a court or tribunal has jurisdiction, the matter shall be settled by decision of that court or tribunal. Now, Article 289 talks about experts. In any dispute involving scientific or technical matters, a court or tribunal exercising jurisdiction under this section may, at the request of a party or proprio motu, that is on its own, select in consultation with the parties no fewer than 2 scientific or technical experts, chosen preferably from the relevant list prepared in accordance with Annex 8, Article 2, to sit with the court or tribunal, but without the right to vote. 290 talks about provisional measures. 292 talks about prompt release of vessels and crews where the authorities of a state party have detained a vessel flying the flag of another state party, and it is alleged that the detaining state has not complied with the provisions of this convention for the prompt release of the vessel or its crew upon the posting of a reasonable bond or other financial security. The question of release from detention may be submitted to any court or tribunal agreed upon by the parties, or failing such agreement within 10 days from the time of detention, to a court or tribunal accepted by the detaining state under Article 287 or to the International Tribunal for the Law of the Sea, unless the parties otherwise agree. The application for release may be made only by or on behalf of the flag state of the vessel. The court or tribunal shall deal without delay with the application for release and shall deal only with the question of release, without prejudice to the merits of any case before the appropriate domestic forum against the vessel, its owners or its crew, upon the posting of the bond or other financial security determined by the court or tribunal. The authorities of the detaining state shall comply promptly with the decision of the court or tribunal concerning the release of the vessel or its crew. Applicable law: the court or tribunal having jurisdiction under this section shall apply this convention and other rules of international law not incompatible with this convention. Then article 294 talks about preliminary proceedings, 295 talks about exhaustion of local remedies, then we have finality and binding force of decision. Then we have section 3 of the part 15 talking about limitations and exceptions to applicability of section 2. What are the limitations? First one will be disputes concerning the interpretation or application of this convention with regard to the exercise by a coastal state of its sovereign rights or jurisdiction provided for in this convention shall be subject to procedures provided for in section 2 in the following cases. When it is alleged that a coastal state has acted in contravention of the provisions of this convention in regard to the freedoms and rights of navigation, overflight or the laying of submarine cables and pipelines, or in regard to other internationally lawful uses of the sea specified in article 58. Then when it is alleged that a state in exercising the aforementioned freedoms, rights or uses has acted in contravention of this convention or of the laws or regulations adopted by the coastal state in conformity with this convention and other rules of international law not incompatible with this convention. Further, when it is alleged that a coastal state has acted in contravention of specified international rules and standards for the protection and preservation of the marine environment, which are applicable to the coastal state and which have been established by this convention or through a competent international organization or diplomatic conference in accordance with this convention. Then there are other grounds for the mentioned reason as far as the exemption of the states are concerned and applicability of 287 article is concerned. Now let us move on to the annexures, where we will look at the procedure and composition as far as different modes of dispute resolutions are concerned. So, we will now look at Annex 5, Annex 6, Annex 7 and Annex 8. As far as the composition of arbitral tribunal, ad hoc arbitral tribunal is concerned, and how does conciliation is to go about under Annex 5. So, we will look at all of these 4 things now. So, starting with Annex 5, which deals with the conciliation. Section 1 talks about conciliation procedure pursuant to section 1 of part 15. Article 1, institution of proceedings. If the parties to a dispute have agreed in accordance with article 284, which talks about conciliation, that parties can also opt for conciliation, it can agree to submit to it to conciliation under this section. Any such party may institute the proceedings by written notification addressed to the other party or parties to the dispute. List of conciliators shall be drawn up and maintained by Secretary General of the United Nations. Every state party shall be entitled to nominate 4 conciliators, each of whom shall be persons enjoying the highest reputation of fairness, competence and integrity. Then article 3 talks about constitution of conciliation commission, and it says that the conciliation commission shall, unless the parties otherwise agree, be constituted as follows. The conciliation commission shall consist of 5 members, and the party instituting the proceedings shall appoint 2 conciliators to be chosen preferably from the list referred to in article 2, that is the list which will be prepared by the United Nations Secretary General. Out of that, 2 will be picked up by the party who has proposed the conciliation, one of whom may be its own national, unless the parties otherwise agree. Such appointments shall be included in the notification referred to in article 1 of this convention. The other party to the dispute shall appoint 2 conciliators in the manner set forth in subparagraph B within 21 days of receipt of the notification referred to in article 1 of this convention. Then, if the appointments are not made within that period, the party instituting the proceedings may, within 1 week of the expiration of that period, either terminate the proceedings by notification addressed to the other party or request the Secretary General of the United Nations to make the appointments in accordance with subparagraph E. Subparagraph E says that within 30 days of the receipt of a request under subparagraph C or D, the Secretary General of the United Nations shall make the necessary appointments from the list referred to in article 2 of this annex. Now, subclause D says within 30 days after all 4 conciliators have been appointed, they shall appoint a 5th conciliator chosen from the list referred to in article 2 of this annex, who shall be the chairman. If the appointment is not made within that period, either party may, within 1 week of the expiration of that period, request the Secretary General of the United Nations to make the appointment in accordance with subparagraph E. Then section 2 talks about compulsory submission to conciliation procedure pursuant to section 3 of part 15. Article 11 talks about institution of proceedings, then its article 12 talks about failure to reply or to submit to conciliation, and apart from conciliation we have annex 6 which talks about the establishment of International Tribunal for Law of the Sea. We will see that what is the composition of ITLAS, what type of ITLAS, what type of disputes ITLAS can undertake, how appointments are made as far as ad hoc tribunals are concerned under ITLAS. Article 1 gives us general provisions, and it says the International Tribunal for the Law of the Sea is constituted and shall function in accordance with the provisions of this convention and this statute. The seat of tribunal shall be in the free and Hanseatic city of Hamburg in the Federal Republic of Germany. The tribunal may sit and exercise its functions elsewhere whenever it considers this desirable. A reference of a dispute to the tribunal shall be governed by the provisions of parts 11 and 15. Section 1 talks about organization of the tribunal. Article 2 gives us the composition. The tribunal shall be composed of a body of 21 independent members elected from among persons enjoying the highest reputation for fairness and integrity and of recognized competence in the field of law of the sea. In the tribunal as a whole, the representation of the principal legal systems of the world and equitable geographical distribution shall be assured. Now, article 3 talks about membership. No two members of the tribunal may be nationals of the same state. A person who, for the purposes of the membership in the tribunal, could be regarded as a national of more than one state shall be deemed to be a national of the one in which he ordinarily exercises civil and political rights. There shall be no fewer than 3 members from each geographical group as established by the General Assembly of the United Nations. Article 4 talks about nominations and elections. Each state party may nominate not more than 2 persons. I repeat, each state party may nominate not more than 2 persons having the qualifications prescribed in article 2 of this annex. The members of the tribunal shall be elected from the list of persons thus nominated. At least 3 months before the date of the election, the Secretary General of the United Nations in the case of the first election and the Registrar of the Tribunal in the case of subsequent elections shall address a written invitation to the states parties to submit their nominations for members of the tribunal within 2 months. He shall prepare a list in alphabetical order of all the persons thus nominated, with an indication of the states parties which have nominated them, and shall submit it to the states parties before the 7th day of the last month before the date of each election. The first election shall be held within 6 months of the date of entry into force of this convention. What will be the term of office is given under article 5, and it says the members of the tribunal shall be elected for 9 years and may be re-elected, provided however that of the members elected at the first election, the terms of 7 members shall expire at the end of 3 years, and the terms of 7 more members shall expire at the end of 6 years. The members of the tribunal whose terms are to expire at the end of the above mentioned initial periods of 3 and 6 years shall be chosen by a lot to be drawn by Secretary General of United Nations immediately after the first election. The members of the tribunal shall continue to discharge their duties until their places have been filled, though replaced. They shall finish any proceedings which they may have begun before the date of their replacement. In the case of the resignation of a member of the tribunal, the letter of resignation shall be addressed to the president of the tribunal. The place becomes vacant on the receipt of that letter. Article 7 talks about incompatible activities. No member of the tribunal may exercise any political or administrative function or associate actively with or be financially interested in any of the operations of any enterprise concerned with the exploration for or exploitation of the resources of the sea or the seabed or other commercial use of the sea or seabed. No member of the tribunal may act as agent, counsel or advocate in any case. Article 8 talks about conditions relating to participation of members in particular case. No member of the tribunal may participate in the decision of any case in which he has previously taken part as agent, counsel or advocate for one of the parties or as a member of a national or international court or tribunal or in any other capacity. Article 12 gives us president, vice president and registrar. The tribunal shall elect its president and vice president for 3 years. They may be re-elected. The tribunal shall appoint its registrar and may provide for the appointment of such other officers as may be necessary. The president and the registrar shall reside at the seat of the tribunal. Article 13 gives us quorum. All available members of the tribunal shall sit. A quorum of 11 elected members shall be required to constitute the tribunal. Subject to Article 17 of this annex, the tribunal shall determine which members are available to constitute the tribunal for the consideration of a particular dispute. Having regard to the effective functioning of the chambers as provided for in Articles 14 and 15 of this annex, all disputes and applications submitted to the tribunal shall be heard and determined by the tribunal unless Article 14 of this annex applies, or the parties request that it shall be dealt with in accordance with Article 15 of this annex. Now, Article 14 gives us seabed dispute chamber and Article 15 talks about special chambers. Now, what is a seabed dispute chamber? A seabed dispute chamber shall be established in accordance with the provisions of section 4 of this annex. Its jurisdiction, powers and functions shall be as provided for in part 11, section 5, which talks about settlement of disputes and advisory opinions. Article 186, seabed dispute chamber of the International Tribunal for the Law of the Sea, the establishment of the seabed dispute chamber and the manner in which it shall exercise its jurisdiction shall be governed by the provisions of this section of part 15 and annex 6. Article 187 says